So some of the biggest red flags, probably the easiest one to spot in a contract is if the contract's too short. If somebody hands you a contract and asks you to sign it and it's only 1 or 2 pages, there's probably a lot of things missing and it's not covering a lot of important details. If a contract includes a lot of language that says you will be responsible for this or you will be responsible for that, as opposed to saying the parties will be responsible for X, Y, and Z. A lot of contracts, especially when they're just handed to somebody, handed to a business owner, will just put most of the responsibility on that business owner. And the company that's giving the contract won't include any language that makes them responsible for anything. Especially in the liability language and the warranty language, if it says a lot of you will do this and you do that, as opposed to we agree to do this or you will do this and we will do this, then there's probably some problems with the contract and probably some room to negotiate those terms to make sure that you are more protected in the long term. So let's say a contract includes a limitation liability clause and the contract says, you agree that you'll be responsible for any instances, accidents, and other liabilities that arise under the contract. That might be a good indicator that it's not necessarily a fair contract. It should include more language and it should explain when you're responsible for the accidents and when the other party is also responsible for the accidents. Because many things can come up and there are different situations where things can go wrong and both parties could be responsible depending on what the issue is. It's best practice to have a contract that's as specific as possible. And I see this a lot, especially with service providers who just include a very vague, broad description of the services they're offering. And if you're the service provider, this could expose you to a lot of risk because scope creep is a huge issue for service providers. When the people you're providing services for repeatedly ask you to do things that you didn't originally include in your contract price, and you end up losing money on the deal. On the flip side, when you're reading a contract and somebody's providing services for you, you should know exactly what services they're providing, so that way you don't run into any kind of disputes or conversations down the road about, hey, aren't you supposed to do this or weren't you supposed to do that? It should be very clear and you should know exactly what you're signing. A good contract should be a guidepost for your relationship with the other party. You should be able to look at that and feel like, I know what I'm getting from them or I know what I'm giving them, without any confusion that could lead to disputes down the road. One big thing that you should avoid agreeing to in a contract is vague termination language or termination language that doesn't give you a way out of the contract if something goes wrong. Some of the biggest disputes that arise between parties is when one party feels stuck and they cannot get out of a contract without potentially facing some kind of litigation from the other party for terminating the contract early. Another contract provision that you should avoid entering into as much as possible is signing a personal guarantee. Or at the very least, if you do sign a personal guarantee, it's important that you understand the implications of signing that agreement. Because by signing a personal guarantee, you put your personal assets on the line for the business's debts. If you can, and sometimes you can, it's great to negotiate a way out of signing the personal guarantee. Otherwise, it's important to make sure that you understand the language in that personal guarantee and also work with an attorney to negotiate that language so that it will protect you as best as possible. If you have questions about how to avoid problematic contract terms, please give us a call at View Ridge Law.